Mazi Nnamdi Kanu. The view has been expressed by those who know this subject that I was misled by amateur legal advisors who turned a serious legal issue into a circus and who misadvised him and who led him to sack people like Kanu Agabi SAN, Ikazu SAN, Paul Erokoro SAN, who are handling the matter. Persons who, from the Court of Appeal in the previous matter, had already provided a template that could have provided a different outcome. And then you have these people, all these social media, Twitter lawyers, misleading him. So, do you agree with that view?
Well,
the situation what eventually happened in the Court of Justice of Motorshow, could it have been avoided if the matter was handled differently?
Well, I do not know why he debriefed those lawyers. I also do not know why he decided to defend himself. But what is those are now in the realm of history or in the realm of the past. What now bothers many Nigerians was what happened on November 20th, the day he was sentenced, and the day he was convicted and eventually sentenced. And the whole issue surrounding the trial, the whole issue surrounding the conviction and the sentencing, the attitude of the court itself, whether the court followed the law or whether the court followed personal opinion of the jurists, or whether the court, in some people's opinion, acted on a script to ensure that Nnamdi Kanu is taken off the streets in a manner of speaking. Whether Nnamdi Kanu defended himself or not, what to many people is more critical and more important is the attitude of the judge and the justice of the matter. Don't forget that in criminal adjudication, one can only be convicted when there is preponderance of evidence, one, two, and when the prosecution is able to prove the case beyond all reasonable doubt. We are not saying all iota of doubt, but at least all reasonable doubt. And that justice must not only be done, but to be seen, manifestly be seen as having been done. The majority of the public of Nigeria and even the international community do not believe that the justice was done in Nnamdi Kanu's case. Don't forget that the issue of treason is a political decision by the state, because treason is an offense against the state. It has been brought to become an offense against humanity. And that is why there is an international convention against treason. And it was to be able to bring it to the level of, to align Nigeria's act with that of the rest of the world, following the UN convention, that brought to the repeal of Nigeria's 2011-2012 terrorism Prevention Act, and reenacted in 2022 with implementation in 2023 of Terrorism Prevention and Prohibition Act. Now, the whole issue about Nnamdi Kanu's matter beggars a lot of questions and defeats a lot of logic, because a lot of people, even now, Nnamdi Kanu himself had continued to say it, even rambunctiously in court, that they should show him the law with which he's being tried. Because by the time many people didn't understand, because all the people who were not privy to the charges and people who were not privy to the goings on in court were at a loss as to why would a man be charged for an offense that is not known to law in a criminal trial. Because a Nigerian statute book says that one cannot be tried for a law of an offense not codified and known to law. And then
under the principle of fair
hearing,
sections 35 and 36.
Absolutely. And there is nothing like retrogressive action in law when it comes to criminal action. Yeah. We are not a military regime. Now,
but Nnamdi Kanu was charged under the old law.
Under the old law.
Terrorism.
He was charged under the 2020.
No, not under 2022. under the older law of 2011.
2013, not 2022, 2013. That was repealed.
The old law.
Oh, the old law that was repealed in 2022.
Yeah, but
So-
the new law will not take effect. That's why Chief Awomolo SAN
Yes.
is saying that the punishment is death penalty. He was quoting the old law, and that the accused person was charged under the old law.
The accused person was charged under the old law. Don't forget that that charge under the old law got extinguished in October 2022. When
Yeah, but the law, you yourself just said it,
Yes.
cannot have retroactive effect.
we cannot have exact effect.
Those are issues they will resolve
No,
at the
that-
level of appeal.
No. There is one major issue that is even on the open.
Okay.
Because in the first instance, don't forget that Nnamdi Kanu had earlier been acquitted by the Federal High Court before federal government went to Court of Appeal. And every moment an accused is acquitted, discharged and acquitted, he goes home from the court. He can only go back to the prison or to wherever he was detained to collect his personal items. If he doesn't want, he can abandon them there. If he doesn't want, he can go from there to his house. If he doesn't want, because at the end of the day, the federal government refused to release him. So at that point of that discharge and acquittal in October of 2022, the court became functus officio. So you can no longer hold on that old law. But by the time you saw the judgment from the Constitutional Court, it was referring to the 2013 charge. So that became a very, very strong issue against that judgment and against the entire procedure.
Okay.
There are so many other issues which time may not allow us to explain.
These are issues that can be worked out when the matter goes to the Court of Appeal. Aloy Ejimako has already said they will go on appeal.
Yes,
and that by Monday, tomorrow, they are going to file.
He has a whole 90 days. We think we to do so.
However,
so you
the
can do
thing
that
to
at
notice
any time.
that Justice Omotosho even said, he was tampering justice with mercy. He was not applying the full teeth of the law. However, what do you think is the way forward? And don't you think that the matter was even complicated by the conduct of the accused person who discharged his own counsel? I mentioned the very senior lawyers who know the territory. Now, in this same case, what's his name now? Ozekome,
Yes.
SAN,
Yes.
was involved. Kanu Agabi, SAN. Paul Erokoro, SAN. Ikpeazu, SAN. These are people who know the law, the in and out of it, who could have provided a different kind of pathway and who could have handled the matter. But where the accused person abusing the presiding judge, and you said, the presiding judge is a problem. What do you expect his lordship to have done in a situation whereby the accused person took over the proceedings of the court and questioned his integrity, questioned his... So what the judge did eventually in the 144-page judgment that I have seen is that he just applied the law. Simply.
Dr. Albert, you may say so, the judge may claim so, but the judge committed what majority of the